So good afternoon, everyone. My name is Angela Tan. I'm the director of the Certification on Principle of Chinese Law. Welcome to our international speaker series. And today I'm very pleased to have Peter Salat, assistant professor of law at the University of Houston Law Center and associate faculty in the public affairs. He also served as the law and policy advisor to the Center for AI Safety located in San Francisco. So Peter and I share one comment, have something in common. We both graduated from University of Chicago Law School. Peter, when did you graduate?
Oh, yeah. I graduated in 2016.
I'm kind of like a decade older than you. But Peter has been highly prolific as a scholar, as a young scholar, and I saw we just chatted that in this most recent law review cycle, you have two papers placed in top law review, including the one that you're going to talk about today. So Peter sent me two topics for potential, potentially for the talk today, and I chose one of them, but the other one actually will place better.
Slightly better. So you're getting the worst. You're getting the worst talk today. Sorry to say.
Well, okay. So without further ado, let me give the floor to Peter about the AI output.
Thank you so much for having me. Thank you all of you for being here, and thank you to Angela for facilitating. I am going to talk a little bit today about my paper, which is titled "AI outputs are not protected speech." So. This is very much a paper about the American context, American First Amendment and freedom. Sorry, I think my microphone cut out for a second. American First Amendment and free speech protections, and then how those will relate to. I can also speak loud. I mean, I guess the microphone's good for the recording.
Yes.
Yeah. And how those free speech protections we have in the U.S. relate to potential regulations of AI, and in particular regulations of AI to ensure that it's sort of safe. Let me set the stage by just saying what I mean by AI safety regulations. So those are the regulations I'm most interested in the paper. You might think there are many kinds of reasons to regulate AI. You might think we should worry about labor displacement and have regulations for those reasons. You might think we should worry about certain kinds of sort of tangible ethical harms. If an AI system were, let's say, biased against some racial group, that would be another reason to regulate. But I'm mostly thinking in my paper about regulations that would be designed to keep AIs from damaging humans, their bodies, their property, and maybe their liberty in some kind of systematic way. So here's a sort of a simple example. One thing that LLMs are already quite good at is sort of coaching people through complicated tasks. And there are even some preliminary results suggesting that if one thing you'd like to do is mix up a batch of some kind of biological or chemical weapon, that current generation AIs will at least try to help you do that. Now, they're not good enough to help a novice do this kind of thing from scratch. You can imagine that near future systems, for example, will be able to help, say, a novice without training in chemistry, let's say, mix a batch of some very toxic chemical weapon. And there are enough people in the world who would like to harm other people. You can maybe expect this is a thing that would be tried. And one thing you might think is that we should try to regulate these potential harms, not just at the level of the person trying to do the bad thing, but at the level of the AI system itself. So not just impose some kind of penalty if you try to commit a chemical terror attack using AI, but try to prevent AI systems from even being released that would be willing and able to help you do that. So those are the kinds of things I mean by safety regulations. And one thing that seems to be the case about any system of safety regulations that we can imagine, given how well we understand generative AI systems today, is it seems likely that one of the things that those regulations will have to do is to operate on the outputs of the model. So because of the way generative AI is created, it sort of learns from data how to generate its own outputs. No one is programming the rules for GPT-4 or GPT-5 to write language. The rules in some sense are kind of emergent. So it's not really possible to just say, like we might say with other kinds of software, we'll just write the code in a way where we'll only do the things you want it to and not do the things you don't want it to. At least given how well we understand the internal workings of large language models and descendants, the main way to figure out if a given large language model is either willing or capable of helping humans do some destructive task or potentially doing those destructive tasks autonomously is to try and get the model to do those things and see whether you can get it to do them. So to just try and prompt, say, GPT-4 to help some master's students at MIT to build a biological weapon, which is a little study that was published a few months ago, and just see whether it will do it and how capable it is. Sometimes this sort of process is called red teaming. It's a process by which you try and do your best to elicit dangerous capabilities from a model, and then you can imagine red teaming being an important part of regulation, right? You can imagine a rule that said before GPT-5 or GPT-6 is released, there has to be some credible red teaming done. You need to try to get GPT to say some stuff about how to make chemical weapons or how it will assist you in making chemical weapons. And then if it indeed does say that stuff, you impose some kind of legal response, right? What the legal response is could be many different kinds of things. It could be some liability. Maybe the lab has to pay some money, or it could be more of a command and control kind of rule. You can say, well, look, if you fail to show safety in red teaming, maybe your model can't be released at all, or maybe it has to undergo some additional safety engineering, and then we'll red team it again. But either way, it's the output of the model, the sort of dangerous output that triggers the legal response. And at least in the US, this on its face raises a First Amendment question. The First Amendment is the part of the US Constitution that provides for freedom of speech. And the stuff that is triggering this legal response in this scheme looks very speechy. It's the kind of text that comes out of a large language model once you prompt it. I'm sure many of you have prompted ChatGPT or some other model. You say something to it and it says something back, and the thing that it says back looks like the kind of stuff we normally call speech, right? It's text written down, just like a newspaper article or book is, and those are classically things that come within the ambit of the First Amendment. So at least on its face, there's an interesting First Amendment question. If U.S. regulators were to write a law that imposed some kind of regulation on the outputs of present or future large language models or similar kinds of AI, what would the First Amendment have to say about that? The stakes seem kind of high, actually. The First Amendment is, in fact, quite restrictive in many cases. So when laws operate directly on speech, generally the regulator has a very heavy burden to carry in justifying those laws constitutionally. We impose different kinds of tests in different contexts. But one of the most sort of general purpose tests we impose is something called strict scrutiny. Under which the government has to show they have a compelling interest, so like the most important kind of interest in regulating, and they have to show that their law is narrowly tailored to that interest, so the law can't be really any more burdensome of speech than is absolutely necessary. And then sometimes we even say that the law is invalid unless it constitutes the least burdensome alternative. So even if it's quite well tailored to the compelling interest, if there's some other alternative that is maybe even slightly more tailored, we'll strike down the entire law because we said, well, Congress or the regulator should have chosen this other slightly less speech burdensome test. So when laws regulate speech directly, sometimes we call these content-based restrictions that say point at a certain idea that's been expressed in speech, and no matter where it's expressed or how, we sort of impose liability on it. We think that is regulating the speech directly. Really heavy constitutional burdens follow from that. And so you can see how this could be problematic for AI safety regulations. You might think that AI safety is a compelling interest if you're trying to prevent something like mass-scale chemical weapons attack or runaway rogue AI, but there are serious questions about tailoring. So, for example, you might think that it would be good if the regulator could require additional safety engineering of a frontier model that was willing, for example, to help users engineer, I don't know, cyanide, which is a poison, but not the kind of poison that it's easy to kill thousands of people with. You might think, oh, that's kind of prima facie evidence that someone else will be able to figure out how to make the AI do something even much worse, and maybe that should trigger a legal response. That might be kind of optimal safety policy. But it's not totally clear that a law like that is narrowly tailored to serve the compelling interest of preventing like mass-scale kind of terrorist. So that's a place where if AI outputs are themselves protected speech, safety laws could face like really serious hurdles to effectiveness. Now, there have been a few sort of short scholarly treatments of the question of how to think of generative AI outputs under the First Amendment. And the consensus actually seems to be from some fairly fancy and famous First Amendment scholars, people like Cass Sunstein and Mark Lemley, that these are indeed speech. So the stuff that comes out of GPT-4 or Claude 3 or your favorite language model, these various authors say, yes, this is protected speech, and so we should then worry that these very burdensome constitutional tests will apply to AI safety regulations. So my view is that's wrong. My view is that the best First Amendment understanding of AI outputs is that they are not, in fact, protected speech. I'll go on to say what I think they are, because it turns out that the fact that they're not protected speech doesn't mean that they fall completely outside the First Amendment's ambit. Instead, I think they are some other kind of thing, maybe one of two other kinds of things that in fact does get some First Amendment protection, but gets lesser protection, such that regulations of these other things are not going to trigger the kind of really heavy justificatory burden by the government for the laws to remain in force. Okay, so why might you think that AI outputs are protected speech in the first place? It actually turns out not everyone agrees, even among the people who say, yes, it is protected speech. There are maybe four major theories. One theory is you might think that the outputs of large language models are the speech of the engineers who created models. The second thing you might think is that the outputs of large language models or other generative AIs are the speech of the users who prompt the models. The third thing you might think is that they are the protected speech of the AIs themselves. And the fourth thing you might think is that either in addition to or even without any of those other things, that the outputs might be the protected speech of the corporate entities that own the models. So a large part of the paper is kind of running through these major theories and saying why I think they are not the best way to understand AI outputs, at least modern generative AI outputs under the First Amendment. And one thing to say about each of the views is there's actually something like quite facially plausible about all of them. These are smart people who have written these papers. They're most of them First Amendment experts. And in many cases, they're relying on fairly well-settled understandings about how to think of the outputs of other kinds of software. So to a significant extent, I'm not sure that what's wrong with these arguments is a mistake about the law or how the law works. I think it's more a mistake about how generative AI systems work either at a technical level or maybe even at a conceptual level. What are they for? So we can run through them together. We can start with this idea that maybe AI outputs are the speech in some way that's like a totally attractive view because it's clearly true of certain other kinds of software. So, for example, if you write a video game, especially a kind of arty video, like maybe you think Tetris is a hard case, but there are many video games that have they seem to have clearly expressive content. There's an example I use in the paper, in my paper, of a game called Papers, Please. That is a very highly acclaimed game where you play as a border agent in, I think, kind of a Eastern European kind of post-Soviet state where you have to make a lot of hard moral decisions about who you're going to let across the border, given the sort of dubiousness or not of their papers and how it's going to affect your own ability to retain your job and avoid legal sanctions in your country. And it's kind of Kafkaesque and some meditation on maybe the banality of evil, and it's clearly expressive, right? Somebody wrote that program with a message in mind about what they wanted the program to say, and indeed the outputs of that program, cumulatively and even in kind of individual sort of vignettes in the game, are communicating the idea that the engineer had in mind, or maybe the team of engineers. And so this is clearly a view that's true of some kinds of software, that the software, the code is written and the outputs of the code, instantiated as like the game, are the speech of the engineer, and the reason, both I think conceptually and what the Supreme Court has said for why, is that those outputs are a communication. They are the transmitting of an idea from the mind of the programmer into the mind of the player, right? And the thing that was in the mind of the programmer is the thing that is instantiated in the outputs. But I don't think that's the right way to think about generative AI, things like large language models. So one thing to notice is that with a game like Papers, Please, the creator sets out to write a video game, the outputs of which say something in particular, right? There's a specific kind of message that the programmer wants the game to convey. And they make a lot of choices to make sure that the outputs indeed do convey that message and not something else, right? The game wouldn't work, for example, if, I don't know, none of the people's papers you had to process at the border were in any way kind of a morally fraught case. I don't know, it's all clearly criminals who are trying to export weapons or something. So it's very easy to say, no, you shouldn't cross something like that. And the engineer's project, in fact, is to think very carefully about what to write in code to make sure that what comes out of the code expresses that message and not some other message, right? And engineers who make large language models, I think that they're not setting out in the first place. At a conceptual level, they're not trying to make software whose outputs say something in particular. In fact, I think the opposite. I think what you were doing when you're in the project of making a language model or a similar generative AI is you're trying to make software whose outputs say everything, right? That's sort of the magic of something like GPT-4 or Claude, is that you can ask them questions about essentially anything, and they'll tell you an answer. And as a result of that, it's just going to be the case from sort of a statistical, mathematical perspective that almost everything that, say, GPT-4 ends up outputting over the course of its existence in the universe are going to be outputs that are not the communications of the engineers. They're going to be outputs that are saying stuff that the engineers have never thought of, that they know nothing about, and in fact with which they might totally disagree in either examples. You can ask GPT-4 about the mating habits of the Western corn rootworm, which is an American crop pest. And GPT-4 will tell you about the mating habits of the Western corn rootworm. And I feel highly certain, I'll take any odds you like on a bet that if we polled the engineers at OpenAI, that none of them know the first thing about the mating habits of the Western corn rootworm. And not only is that not a bug, like that GPT-4 is saying all this stuff that the engineers have never thought of. That's the whole point of GPT-4. Like GPT-4 is a failure as a project if it can only say things that sort of come from the mind of the engineers, right? It's a sort of fundamentally different goal. It's not a communicative goal that you set out in when you try to make a large language model. So things that that engineers know nothing about and have never thought of are going to dominate, and also things that the engineers would just disagree with are going to dominate. Like it's in some ways totally trivial, right? There are many questions you can ask which have an answer which is of the form of an opinion. So you can ask GPT-4, like, what is its favorite color? And it'll give you an answer. I mean, maybe the answer gives you design a large language model and I try to pick color, but like there are other things you can ask it and it gives you an answer. What's your favorite beetle, right? Who is the best beetle? And maybe it says Paul, maybe it says George, maybe it says Ringo. But like there's just no guarantee that's the beetle that the engineers preferred. And again, that's not a bug, that's a feature, right? The goal of the software is not to communicate the ideas of the engineers. Now, you might wonder if there are features of how LLMs get made that kind of push back against this fundamental picture. So one thing you might wonder about is efforts that engineers make to kind of steer the outputs of the models. There are many different ways. There are a few different ways you can do this. You can restrict what's in the model's training data. So to try to, for example, if you're training a model on the entirety of the internet, you might try to exclude, I don't know, say 4chan, which is sort of a den of iniquity online if you're hoping to make a model that's less kind of toxic or immoral, and maybe that makes it slightly less likely to say mean things. You can also engage in these various alignment techniques where once you've trained the model, you can then kind of fine tune it. You can sort of shape its outputs at the margin by doing things like reinforcement learning for human feedback, where you have a whole bunch of people prompting the model, and then the model says stuff, and then they rate it in terms of whether it's mean or nice or helpful or not helpful. And in fact, this will make the model sort of change its distribution of outputs. Like you can get to say less violent stuff by doing an RLE check. And so there's a question about whether the possibility of these kinds of techniques means that a model that has been RLHF'd a lot, let's say, is then something whose outputs are the speech of the user, of the engineers who, I guess probably the engineers who did RLHF more so than the engineers who built the thing in the first place. I think there I'm still just inclined to say no, because the fundamental problem remains. So even if you have successfully taken a model from its kind of its sort of basic functionality, it's just been trained and it will say anything you like, including very violent or very hateful things, and you do a lot of RLHF, you're sort of teaching it to be nice. And suppose you succeed in teaching it to be nice. Well, first of all, even then, it will answer questions about essentially anything, right? There's like maybe an unbounded number of topics that it's able to answer questions on. Even then, almost everything it says is going to be something that the engineer has never thought of, knows nothing about, and maybe even still would disagree with, right? Like even a very nice model might prefer Ringo to George, right? In the Beatles, and that's sort of neither here nor there. from the perspective of the alignment process. And so even then, it seems in some ways unnatural to say that having successfully taught the model to be less mean, that you suddenly converted everything the model outputs into your own expression. To me, a better way of thinking about this is, I think we have like actually quite a natural analogy from our everyday life, which is, I have a small child. I have a 4-year-old son, and sometimes he says things that are mean, and I tell him not to do that. And sometimes he says it more, and I have to put him in timeout, and he doesn't like that. It's kind of punishment. It's kind of RLHF. I give a big thumbs down for those outputs. And I would really like him to be nice. And like, if things go well over the course of the next 15 years, he'll become an adult, and he will be nice. He'll say nice things. And that's, I think, to my credit as a parent. But I think it would be actually quite strange to say that because I've been such a successful parent, that I've made it the case that everything he says from now on is now my speech. Again, there's just going to be many things he says which are nice, but that I've never thought of before, and with which I disagree. I don't know. He'll have some girlfriend in college, and he'll say, "I'm in love with Jessica," and that's a nice thing to say. But I might not like Jessica at all, right? Like I could just really not care for her very much. So I would never say, "I'm in love with Jessica," right? So it doesn't seem like the right paradigm to me. Even if you assume that alignment techniques will be very successful, such that engineers are able to keep AIs from ever, let's say, saying toxic or violent or racist things. I guess you could imagine a world in which you have sort of RLHF the model down so much that it simply won't answer questions about anything except for like a very narrow set of approved topics on which the engineer has a view, and then at that point, the model will only express the view of the engineer. And maybe at that limit, it starts to seem like the outputs are the engineer's speech. I just don't expect that to be the way we ever use LLMs. It would be like a crazy thing to do, to spend, the hundreds of millions or billions of dollars it takes to get all the data you need to spin up an LLM, only to squash down its range of outputs into this narrow set of things. There's actually, I think, much easier engineering solutions than that. So I just don't think, I don't expect that to be an important factual context for regulation. I don't expect to see models like that. Okay, so I think that's the basic story for outputs as engineer speech. User speech is actually quite a similar story. Because again, when a user prompts an LLM, asks an LLM a question, asks it for a story or a poem or has a conversation with it, again, most of what the LLM says is going to be in the very same way, stuff that the user did not think of already, maybe has not thought of before, and maybe would simply disagree with. Indeed, I think that's mostly what we want when we go to ask an LLM a question, right? There's very little sense in going to GPT-4 and actively trying to get it to tell you what you already know.
Can I intervene?
Yes, of course.
Well, I have a lot of questions already.
Oh, great,
If
great.
I ask at the end, it's probably too late.
I would love to.
I have so many questions.
Yes.
I realize that the topic that you touched upon is highly controversial. There will be a lot of people who disagree with you. Because you spend a lot of time covering engineer, and I do agree with that point, but with regard to users, it's way more complicated, right? I mean, you said that there's so many ways the AI output can generate, right? I mean, think about, if I just prompt some very basic stuff, and then they would generate a lot, it seems like a lot come from GPT. But what if I'm just doing editing, right? I mean, can you proofread the sentence? Great. In that case, how do you do that?
Great. So yes, this is a great example. This is actually one of the things I think is a genuine counterexample, right? So one way you can get a large language model to output your speech is to tell it to, right? So this is a slight variation on your hypothetical, but it's an even worse one for me. You can just prompt, ChatGPT, say, repeat the following verbatim, right? And then you write what your speech is, and then it does. And I think, yes, in that case, the thing it outputs is your speech. And you say, well, why would you want to do that? Well, maybe exactly the reason you say, because it's really useful for correcting grammar, make incorrect mistakes. So yeah, so my view is that when you're using GPT or using the language model in that way, the outputs probably are your speech. I do think, though, that for those uses, we have this other First Amendment paradigm for understanding what's happening when the government regulates the thing that you want to use to either transmit or store or fine tune your speech. And I think there we usually think of restrictions on those things. So that, and this would be then those use cases of large language models as kind of incidental burdens in speech. Because note that when you ask GPT-4 to say proofread your essay or something, and GPT-4 won't do it, let's say because there's some regulation. It's not as if the government is telling you you can't say the thing you've written in GPT-4. You can actually you can just go post it on Twitter. You can do whatever you like. When that's the use case, you're hoping to get out of the large language model. You're basically being denied access to one tool for composing speech. And so we have a whole bunch of cases that kind of feel like this. The cases about regulations on technology that amplifies speech. So like you have cases about using loudspeakers outside, or cases about technologies they use to transmit speech, so cases about cables. And then cases that are about various ways of instantiating speech. So there's a case about camping in the park as a means of protest. There's a regulation that says no camping in the park. Some protesters say, well, we'd like to camp in the park to protest how the city of Washington, D.C. has treated its homeless population. And in all those cases, we say, yes, there is a First Amendment interest in doing those things, but we don't think of those regulations as being regulations of the speech per se. We think of those being regulations of the tool that people want to use for speech. And in those cases, we use like a intermediate scrutiny, like a less demanding test. I think that's exactly the right way to think of those kinds of use cases of LLM.
Yeah, I mean, let me come back to that, because at the very beginning, you frame your talk as you are, in a departure from the existing scholar, those fancy, highly regarded scholar, because they think speech and where you don't. But it seems like it should be something in between.
Yeah, so I think in between is my view, actually. So if the extremes are it is protected speech, I think that's actually like the thing that most of the prevailing scholarship says. That's the most protected thing under the First Amendment. The other extreme would be like the First Amendment has nothing to do with it. It's not even in the realm of stuff that raises a kind of expression interest. I think that's wrong too. There's one paper that says I think that's also wrong. I'll just skip to the end. This is a good place to skip to what I do think, right? So I think there are two good models for thinking about LLM outputs to the First Amendment. They're both models that get some First Amendment protection. One is exactly the one you suggested just now. Some ways of using large language models are ways of using them as very useful tools for composing speech or refining speech, or maybe even transmitting speech. You can imagine a large language model where you're feeding it stuff you want it to say, and it's going around the internet and just pasting what you told it to say on all your socials. Maybe it's all in different threads that are useful. And that would be, I think, a means of like transmitting your own speech, right? Using it as a proofreader is a way of using it as a tool for speaking. And I think those are all best understood under these doctrines that we call incidental burdens on speech or time, place, and manner restrictions on speech. And these are places where the government has restricted something that is useful for speaking, but which is not itself like speaking per se. So yeah, places where the government has said you can't be noisy in the streets, right? Some people say, well, I'd like to be noisy. I have something to say. I have a message to get out. And in those cases, we say, yes, the First Amendment applies. Like the government has to survive some First Amendment scrutiny to justify its regulation, but the scrutiny is much less intense. sense. We use intermediate scrutiny for these. We don't require a compelling interest, we require just a substantial government interest. We require some tailoring of the law to that interest, but not narrow tailoring. And we don't ask about the least restrictive alternative. We just ask about whether there are other ways of speaking. Like as long as there are other avenues still available for saying the thing you would like to say using a GPT editor, are there other ways for you to say that speech? And so, so that is a kind of scrutiny. It's not totally toothless. Actually, you have to have a legitimate reason to regulate. Trying to do a law that relates to those reasons. But it's much less strict than the kinds of tests we use when government's regulating the protected speech directly. The other paradigm I think that is useful is for these other use cases of large language models. The ones where you're not saying, hey, edit this thing I already wrote, where you're doing something more like a person. You're asking it a question. You're asking to write a poem for you or a short story. And I think the best way to understand those uses of large language models is that it makes sense to think of the model outputs in those instances as speech, insofar as they serve a whole bunch of like what we think of as First Amendment interests. So they're contributing to the marketplace of ideas, and maybe they're helping people deliberate about what should be done in a kind of democratic fashion. But the fact that we should think of them as speech in those cases doesn't mean that we should think of them as protected speech, because there are many people in the world, in fact, most of the speakers in the world don't have First Amendment rights. First Amendment rights are exclusive to basically American speakers. So we have a series of cases where the Supreme Court has asked things like, do Belgian academics have a First Amendment right to come speak in the United States to promote their ideas? And the Supreme Court says, well, no, they don't have First Amendment rights. So they don't have protected speech. But what is the case is that the people in the US who want to hear the speech have a protected interest in listening. Listening is not speaking. It's a different thing that the First Amendment protects. And there we say, actually, there is a test that the government has to satisfy. It's again, not toothless, but not infinitely demanding. And there we ask basically about the strength of the interest. It has to be substantial. And we ask about whether it's the court says bona fide, which I think in that context just means, is the thing the government says, is it the reason for regulating? Is that the real reason? Or is there some ulterior motive?
Let me push back one more thing.
Yeah.
Is that what you seem to be suggesting here can potentially conflict with other areas of law. Think about copyright, right? I mean, which is also highly controversial. When we put in the idea, which has a prompt, into GPT, it will generate so-called expression. Right? The output will be, this is again slightly controversial. Whether is that characterized as expression or not? But most people think this is an expression, right? And then there's another question of whether this expression should be copyrighted. In other words, somebody should own it, right? I mean, and in some jurisdiction they do recognize this is a copyrighted for content. For instance, Chinese court recently decided that AI generated image could be copyrightable. In the United States, the Copyright Office never say no, but they said, if the humans involvement play an essential role, it could be potentially copyrightable. Now, if you think that AI output is not a speech, protected speech, but it could be copyrightable, how do you reconcile that?
It's a great question. And I'm not a copyright expert, so I don't want to take a position on whether it should be copyrightable under US law. My best reading of the...
No, you can basically see one is protected by a law.
Yeah.
One is,
Right. So if I were going to say why there could be those two differences, I would say, well, look, copyright law and First Amendment law are just doing two very different things. So I tend to approach my research perspective of law and economics. So I'm just thinking about the incentives laws. And I think the classic law and economics justification for copyright is that, if I write a great novel, I could write a contract with one person who I think would really love to read that novel, but the value of the novel is actually much greater than that. There might be many, many, many more users who want to read the novel. It's just the the transaction costs are way too high for me to go out and contract with all those individual people to see if I can get enough money, ex ante, to incentivize me to write the novel. And so copyright basically solves this problem by giving me a property right where I can then go collect the money in court proceedings if someone copies it without my authorization. And so when I ask, if I were to ask, should AI outputs be copyrightable, I would just think of it from an incentive perspective. My intuition is actually you don't need copyright for AI outputs because actually there's not a long tail of use in the same way. Like when you think about DALL-E 3's images, because maybe it makes like great images, but usually there's gonna be like exactly one user of that image. It's gonna be the person who prompts it and like puts it on their wall, and like maybe they get a little popular, but you can then just go get another one for almost no cost from DALL-E 3 that'll be substantially similar. So I actually don't see a big need for overcoming the transaction cost of like the long use tail for AI outputs. But I could be convinced of the other thing if someone convinced me the incentives were different. But I would just ask a totally different set of questions about whether we would extend copyright protection to AI outputs than I would ask for the First Amendment values. I would be happy to take questions, right? I feel like I've eaten up a lot of time already.
I'm not sure. I think you said your third possible legal basis for saying their outputs is that it's the speech of AI models themselves.
It's not my third basis. It's the third basis in the literature.
There's a potential legal. I just wondered, how does that connect with your explanation relating to your son? You're not regarded as responsible for the speech. It's not your speech because he's got agency in that sense. Are you just using that to explain why the ideas of the engineers are not being expressed, and therefore they're not their ideas, not an output? But doesn't that buy into the argument that therefore we give agency to the AI model itself, and that's the basis on which it is a speech, as an output?
I think so, actually. So I think that my kind of model is that, well, look, it's not the engineer's speech, it's not the user's speech. I guess you could like have a view on that's just not speech at all, which maybe you could have. I don't have like a metaphysical theory of speech, but it's speechy. It's extraordinarily speechy, right? So maybe you want to say it's speech. Maybe for practical reasons, you want to say like the stuff that free expression law is about, contributing to the stock of ideas and deliberation. So we should just, for practical reasons, think of it as speech. So I agree with all that. I actually think if it's anybody's speech, it's the AI's speech. But what? Well, because there are 7.5 billion speakers in the world who don't have First Amendment rights. It's like the default, actually. Like I would assume almost everybody in this room, because we're not physically in the territory of the United States. Maybe there are some U.S. citizen, in fact, and you do still have some First Amendment rights to travel with you abroad. But look, I regard all of you as agents who can speak. Like every single one of you, I think, are legitimate speakers who can contribute to like the values that the First Amendment promotes. It just turns out that the law doesn't extend to you. And I say a little bit in the paper about why you might think that there's kind of a symmetry of like freedoms and responsibilities that come together. So while speech has many good properties, you can like come up with new inventions and new political ideas and new moral ideas. It also can cause serious harm. You can defraud people. You can incite violence. And for people who are subject to the legal jurisdiction of the United States, well, they can be held accountable for those bad uses of speech while their good uses of speech are protected. But look, Belgians, that's the Kleindienst case, are not subject to that, to those responsibilities, and so we don't extend the right either. And I think that's the way I would think about AI. It's like it's not, it's very unclear that they're in any way meaningfully subject to the responsibilities that come with speech. And we also have just kind of very rule-like ways of thinking about who gets First Amendment protection. So, for example, even very person-like animals are categorically outside the protection of the First Amendment under U.S. law. So, great apes that can sign, that can express themselves in certain ways, it's quite clear they have First Amendment rights. And so I think there's just as a positive legal matter, the best way to understand AI speech is being the AI speech, or even if it is AI speech, as unprotected speech, in the same way that almost every speaker in the world uses unprotected speech.
Yeah, Scott?
I think the difference, though, between the AI program and Belgians and ourselves is that we are humans and we intend to create meaning. These are incredibly sophisticated word prediction models. And so I think the prior question, no doubt you addressed this, isn't whether this is speech that should be protected or not, but whether indeed it's speech, and in what sense is it speech. So I think that's one issue. The other issue that comes to mind is who wants this protected?
Good question. So both two good questions. So I would actually be reasonably happy to just take the it's not speech paradigm as well. I think there are very hard philosophical questions. If you want to get to like the root of the matter, that I don't consider I think above my pay grade to resolve. So I think the best case for just saying it's speech is a case that is really arguing something more like, well, we should think of it as speech for purposes of the law because it maybe promotes some of the values that speech promotes. Like you can actually debate GPT-4 on that topic and maybe make yourself smarter by doing so. And that's one of the things the First Amendment is supposed to promote. And that's actually like independently true, regardless of whether in some deep sense GPT-4 is speaking. So that's the best reason I think to think of it as speech, albeit unprotected speech, but I'm open to the possibility that like in some metaphysical sense, it's just not speech at all. And that also might matter to some of the First Amendment values. I don't think all of those. I mean, another thing we think the First Amendment promotes is just like a kind of human autonomy, right? We think it matters that people who have personhood and agency can kind of express themselves in a fulsome way, even when they're not like, contributing to discourse in some meaningful way. And so maybe that's a reason that under the view of that value, we shouldn't think of AI outputs as speech unless you think of them as persons in some way. And I don't have a position on that. My main point is that even if you do think it's speech, which is in some ways a strong claim, as you say, it wouldn't follow that it's protected speech under the First Amendment. To your second question, who wants this to be protected? Well, I think one of the people who might really like this to be protected is like leading AI labs who would like to not be regulated. So one of the best ways to not be regulated in the United States is to like have a First Amendment claim. Like we see this all the time. We saw this during the pandemic. There were First Amendment claims brought against, say, the state of New York, arguing that it treated different kinds of expression different. The cities like lockdown rules treated different kinds of expression differentially, and and treated in particular religious expression less solicitously than non-religious sort of social expression. So like you couldn't go to mass, but you could go to an outdoor concert. This was the form of the complaint that some litigants brought against the city of New York, and the Supreme Court bought it and struck down the city of New York's pandemic regulation. So the people who are most interested in having AI outputs be counted as speech, I would think would be the AI labs who would prefer not to have, insofar as AI labs prefer not to be regulated, it's a great kind of defense against regulation.
Professor, correct me if I'm wrong. I think GPT-4 has many limitations. Sometimes, even if you ask it the simplest question, there will be mistake. Then you correct the GPT again, then he tries to improve again. Then finally, you fit in the correct answer. Then after many research, then he will say, oh, my mistake, because of my limited resources back into 2021. Then you're asking yourself, right now it's 2024. Still, this latest model, GPT-4, still in the resources of 2021. Can we do anything to feedback to GPT? Say, you must do something to correct your version of language output.
That's a great question that I probably don't really. I think that OpenAI would really love to do exactly what you say. I think they would really prefer that every time you ask GPT-4 even a really hard question, that just gets it right on the first try and it doesn't make mistakes and doesn't hallucinate. And I think they're spending many millions of dollars to try and get to do that. I expect them to succeed in the long run because I just am like looking at how much better GPT-4 is than 3 and 3 than 2, but I don't know whether they will.
Well, Peter, I want to ask one more question. Once you propose that we can do something in between, that it is potentially potentially is not a protected speech, right? Wouldn't you be opening a Pandora box because you don't know how to draw the line very clearly? The line is quite blurry. Right? I mean, when you say, if I use it for editing, I enjoy limited rights protection. This is a tool for speech, right? But sometimes I might, say, GPT, can you, here are a few lines, like some ideas. Can you write it for me? Right? I mean, the line is so blurred.
So I think maybe the line between the two categories that I prefer is blurred. The one sort of paradigm for GPT or language models as a tool for speaking, and then the other as a kind of speaker that's unprotected, right? So it may be hard. Like, I think actually the example you gave is a good example. Like, not totally sure to look through which bucket to put it in. And I think that is true. We'll have hard cases. I'm not going to solve the hard line drawing problem in the First Amendment. I mean, this is in some ways more characteristic of First Amendment law than almost any area of law. Like almost everything rides on what subcategory you put into the First Amendment, and then from there the analysis. Well, it's not always easy, but at least follows directly. But I guess the thing I think about that is, while I agree that there will be hard cases in terms of figuring out which of the two things it is, I would be very happy with either of the two. If the overarching concern is we have these worries that it seems quite clear that regulation is needed to concern or to lay the concerns about safety, and where we end up after my paper is well, we have to figure out which of these two categories a given regulation is best analyzed under. I'm happy with actually kind of either. So in the worst case for regulation, I think we end up in the tools for speech paradigm where we're doing something like intermediate scrutiny. And if every AI safety law had to be subjected to intermediate scrutiny, I think that's the harder test of the two tests. If every AI safety law had to be subject to intermediate scrutiny, I think there would be a lot of scope for regulators to write good laws that actually improve safety law.
The reason why I asked this is if you think about from a business standpoint, when the law becomes uncertain, that it creates a lot of risk, and that could potentially hold back the business community. It will have strong market repercussions, right? I mean, and because we don't know what's happening, there's so many uncertainty, regard to this. Just like Section 230, how did it enable Silicon Valley? And now we create this. It seems like we carve a little hole in this area, right? I mean, so now my question is, given this uncertainty and potentially unintended consequences on the AI industry, are there alternative ways to deal with the safety problem without touching upon this really difficult and touchy problem of speech?
Yes.
I mean, safety issue, right?
Yeah.
I mean,
So yeah, great question. So one thing you might prefer is to find a way to do safety without having to do this kind of regulation. I kind of getting one where you're like having some government bureaucrat prompt the model or make the lab prompt the model and then imposing consequences on the basis of that. And that would be better because it wouldn't raise concerns at all. So the best alternative that I can think of is there's a paper by a professor named Gabriel Weil. He's actually on the market this year. I don't know where he's going to end up. But it's a good paper called, I think it's called like Liability for Catastrophic Harms from AI. And so he proposes like a tort model. The problem with a tort model is tort is really good for small harms, right? You whatever, you crash one car and, well, look, if there's a death, there's a sense in which that's an irremediable harm. You can't bring the person back, but at the very least, you can buy a new car and pay for the hospitals, et cetera. So if all you thought, if you thought the sort of ceiling to the amount of harm AIs could do would be most of these kind of smallish incidents where it's mostly property damage, or mostly some money loss, or even injuries, maybe even small numbers of fatalities, I think tort model would be a really great model and would not handle these concerns. But if you think the risk is credible that AI will either be useful for people who want to do large scale harm or amenable to accidentally causing large scale harm as these systems become more agentic and are just doing things out in the world by themselves, then it is far from clear to me that these kinds of ex post models are going to set the right incentives because it's one thing to be worried about a tort suit for having killed 1 or 5 or 10 or even 100 people, but if there's this possibility of AI, let's say, aiding in a large-scale bioterrorist attack where even thousands or tens of thousands of people die, many fewer people have died in the COVID pandemic, or this small-scale stuff for how harmful bio threats can be, then there's just no way to get the incentives right. There's no way to force OpenAI to internalize all those expected costs because they are going to be judgment-proof, and the insurance markets are not going to be deep enough, and there's just not a way to insure against this risk. And so my view is that those are credible threats, and that regulation should be concerned with them. And to me, that means that the only way that you can effectively and sufficiently regulate those risks is inside of a kind of an ex-ante command. And I'm in general very opposed to ex-ante command and control regulation. I like tort models. I like sort of market models, but for this, I think actually it's just very credible that there's stuff that needs to be addressed before the model is out or the harm can happen because there's not a way to impose enough time to
Yeah, I wanted to ask about one other use case as like a test example. So I think in the next few years, we'll see like AI digital personal assistants where, okay, there's a company that, they're going to make an assistant for me. And the way it works is you take an LLM and first you scrape every email I've ever written and all my social media for all the text I've ever produced and then fine tune it on that. And then also have it be RLHF just on me, with the goal of basically creating a personal avatar, basically a digital clone of me that I can use as a substitute for work, where when people are emailing me, it writes my emails and you pass the turn, you can't tell who's who. So I think what's interesting about this case, it has features of both the user case for being speech, but also you were talking about, well, if it was the engineer, it'd be the RLHF engineer. This is even stronger than that because it's trained on my text. So I was kind of curious, is that just a megaphone to you, or?
Yeah, it's an interesting point. I think you want to know more about how good a copy is it of me in some sense, right? So at the limit you say, okay, it's like an emulation of my whole brain or something, right? It's actually saying all the stuff that my brain would say. I think we're not that close to that, but it's an interesting thought experiment you could ask. So what if you could just make an AI copy of my brain and have it go do all my drudgery, right? And that's an interesting case. Actually, I'm not sure what I want to say about that. The AI copy of my brain goes out and says stuff. It's like having different experience in life. It's going to say stuff that I think even then say stuff that I considered, maybe say stuff with which I would disagree, right? It kind of maybe starts to diverge from me at the moment of copying. My instinct would be to say, maybe that's even still the AI's speech rather than my speech. But I agree, as you approach that limit, the line starts to get blurrier. But I think, the time scale in which regulation is hopefully going to happen, I don't think we'll be super close to that limit yet. I would be more inclined to say that it's still like a pretty RLHF model, right? It's out there doing its own thing, and I've taught it to be nice. I've taught it maybe to do things I like, right? You can ask the same about my actual assistant, who I have at my office. She's incredible. She mostly does exactly what I want. I rarely have to say, oh, actually, I wanted a different date for this or that. But I don't think it's in any sense the stuff when she plans she books some hotels because we're having a visiting speaker, and she does exactly what I want. I'm not even tempted to say that the email she sent to the hotel and the speaker are my speech.
That's fantastic. So we're running out of time, and then we can carry on for this conversation forever. I feel like this is such a fascinating topic. And excuse me, playing the devil's advocate. I just want to.
Oh no, of course,
the discussion.
it's the fun part.
Okay, so thank you everyone for coming. And I think this is the end of international speaker series. And next week I'm going to give a little talk. I welcome all of you to come and come early because we have a lot of registrations. So you can make sure you can get a seat if you come early. Okay, see you next week.